This case before us deals with the asymmetric federal model of governance in India involving the contest of power between a union territory and the union government. The issue is who would have control over the services in the National Capital Territory of Delhi, the government of the NCTD or the Lieutenant Governor acting on behalf of the union government. The question arose subsequent to a notification dated 21 May 2015 issued by the Union Ministry of Home Affairs. The limited issue for the consideration of this constitution bench only relates to the scope of legislative and executive powers of the centre and NCTD with respect to the term services. That is to say, whether the NCTD or the union government has legislative and executive control over services. Then we deal with the constitution bench of 2018 and say, we are unable to agree with the view of Justice Bhushan in the 2019 split verdict. As indicated previously, the majority decision in the 2018 Constitution Bench judgment rendered a broad interpretation of Article 239AA(3)(a) to provide NCTD with vast executive and co-extensive legislative powers except in the excluded subjects. A combined reading of the majority opinion and the concurring opinions of Justice Chandrachud and Justice Bhushan indicates that the phrase "insofar as any such matter is applicable to union territories" does not restrict the legislative powers of NCTD. While the 2018 Constitution Bench judgment provides sufficient clarity on the interpretation of the phrase "insofar as any such matter is applicable to union territories," we find it necessary to deal with the arguments made by the Union of India that the phrase must be read in a restricted manner to limit the legislative power of NCTD on certain subjects in addition to already excluded subjects in List 2. Article 239AA(3)(a) confers legislative power to the NCTD. However, it does not confer legislative power to NCTD over all entries in List 2. Article 239AA(3) provides multiple safeguards to ensure that the interest of the Union of India is preserved. First, Subclause A of Clause 3 removes 3 entries in List 2 from the legislative domain of NCTD. It provides that NCTD shall not have the power to enact laws on matters with respect to entries 1, 2 and 18 of the state list and entries 64, 65 and 66 of that list insofar as they relate to the said entries 1, 2 and 18. Second, Subclause B of Clause 3 clarifies that Parliament has the power to legislate on any matter for a union territory, including on subjects with respect to which NCTD has legislative power under Article 239AA(3)(a). In other words, Parliament has a plenary power to legislate on a subject in any of the 3 lists of the 7th schedule for NCTD. Third, it provides that where there is a repugnancy between a law enacted by the Legislative Assembly of NCTD and a law enacted by Parliament, the latter will prevail. The law enacted by the Legislative Assembly shall, to the extent of the repugnancy, be void. Unlike Article 254, which provides for the overriding power of Parliament only on subjects in the concurrent list, Parliament has overriding power in relation to the NCTD over subjects in both List 2 and List 3. Fourth, the second proviso to Article 239AA(c) provides that Parliament may enact at any time any law with respect to the same matter by including a law adding to, amending, varying or repealing the law so made by the Legislative Assembly. Fifth, under 239AA(7)(a), Parliament may by law make provisions for giving effect to or supplementing the provisions in the foregoing clauses of 239AA and for all matters incidental and consequential thereto. The article stipulates that such law shall not be deemed to be an amendment of the Constitution for the purposes of Article 368, which deals with the power and procedure to amend the Constitution. Thus, Article 239AA(3) balances between the interests of NCTD and the Union of India.